This is Chris, the court reporter.
Hello, Chris. Oh, yes. There are so many people. I'm looking, my screen is really large and I have to look all the way to one direction to see you. How have you been, sir?
I've been okay.
Good, good, good.
Just getting tired of working at home,
That's what a lot of people say.
Yeah.
Mr. Chavez, we are now live.
Okay, good, folks. Good morning, everybody. I see Mr. Saucedo. I see Mr. Chavez, Miss Williamson, and there are other folks, I believe, that are here, but let's get started with the preliminaries. Hold on. Okay, good morning, folks. We're on the record, as Mr. Moya has indicated. Today's date is May 3rd, 2021. I'm Stephen Chavez, the city's land use hearing officer. These are consolidated appeals, time-sensitive appeals. We are holding a quasi-judicial administrative hearing regarding those appeals from the zoning hearing examiner. And these two appeals are AC-21-4 and AC-21-5. Now, a record of this hearing is also being made by a certified court reporter. Let me note that when I reviewed the records for these appeals, I noticed that the records are incomplete. So number one, the remand order for AC-21-10 is not in the record. So I want to make sure that that gets into the record at some point in time. I also note that the previous records of AC-20-10 and AC-20-11 were not included in this record. I think they are entwined and they are certainly associated with the issues of this appeal, and they deal with the same facts, same applicant, and the same location. So I need to get those into the record as well. Are there any objections from council regarding those two issues?
No objection.
Thank you so much. Okay. Are there any preliminary matters with the appellant before we proceed? Mr.
No issue.
I saw you moving your head.
I'm sorry. I'm trying to bounce between mute and unmute. And no, we do not have any issues at this time.
Okay, good. And who will be presenting on your behalf, on the appellant's behalf?
I appreciate that. I will, since we are essentially dealing with the legal argument. However, as you noted, Mr. Chavez, also from Saucedo Chavez, is here today, as is Angela Williamson with Modulus, who of course was the agent and primarily presented at the earlier hearings. She is certainly most knowledgeable about Murphy Oil and some of the specifics, although I think we're past that. But if that happens to come up, she is certainly here today.
Okay, good. Well, let's proceed. Mr. Chavez, is there anything that you would like to get on the record at this point?
Good morning, Mr. Chavez. No, I think Mr. Saucedo will be doing all the arguing, legal and otherwise, on behalf of the agent. Thank you.
Okay. Now, in these appeals, I always reserve time for the party opponent. I didn't notice that there was a party opponent in this appeal. I do note that I did receive some supplementary information, essentially the arguments that were in the last two appeals from the neighborhood association. Is there anybody from that neighborhood association that is here today to present their arguments? Anybody at all? Okay.
Yeah.
Yes, Mr. Benz. Hello.
Yes. Thank you. I was presenting at those same arguments at the earlier appeal that the neighborhood association made. And since our president is out of town, it looks like I'll be the one to make any statements that the neighborhood association would like to make. I believe also that the Alamosa neighborhood association is either present or people from that neighborhood, the one that directly behind the lot in question. So if one of those people is speaking, they, I guess, would identify themselves now.
And that is the Alamosa Neighborhood Association.
Yes. And I'm speaking for Los Altos Neighborhood Association.
Okay. Now, just for our record, I note that I did receive the supplementary information, essentially, which was the same arguments, the exact same documents that were presented to the ZHE that were in the previous records. I've included those previous records in this appeal.
Right.
So I think you're covered. Is there anything extra that you would like to include in the record, sir?
No, I think our point here today is to hear what Murphy has to say, and we'll respond to that.
Okay. Okay. Now, is there anybody here that's representing the Alamosa Neighborhood Association?
My name is Gerard Garcia.
Mr. Garcia, good morning.
Good morning.
Before you make an argument, my question to you is, are you going to make an argument?
I'm basically present to observe, and
Okay.
if I have to make an argument or respond to counsel or whatever, I'll be available.
Okay. I am not going to call on you. So the way it goes is the appellant will make an argument based on the record, because this is a record review. It is not essentially a second stab at the issues. It is a review of the record. So I don't allow new evidence unless I believe that new evidence would be necessary to clarify what's already in the record. But I will allow you time. I will ask you after the appellant and Mr. Benz makes their arguments. I'll ask you is there anything you would like to add to the record at that time, okay? And at that time, I will swear you in.
Perfect.
And if I don't swear you in, please remind me to swear you in, okay?
Perfect. Thank you.
Okay, and the same goes for you, Mr. Benz. Okay, and counsel, I don't need to swear you in because you are an officer of the court. Ms. Lopez, I see, are you here with the Neighborhood Association?
Good morning, Mr. Chavez. Senator Linda Lopez, I am here in support of my neighborhood associations. So
okay, so you're basically here to observe.
anything afterward. Thank you.
Thank you so much. Okay, and Ms. Williamson, I will allow you to testify if Mr. Saucedo calls upon you to testify. I may have questions for you if Mr. Saucedo can't answer those, and then I'll swear you in at that time, if that's okay.
Yes, hearing officer, that would be great. Thank you.
Okay, good. Mr. Saucedo, proceed. And take your time. I'm not concerned with time in this hearing, so take all the time you need. If you become repetitive too much, I will politely interrupt you and ask you to move on.
Well, I appreciate that. And frankly, I always try to avoid being repetitive. So hopefully that will not happen. However, Mr. Moya, or excuse me, Mr. Sanchez or Mr. Moya, I guess, may I have the share screen?
Yes, give me 1 second.
Great.
Okay, I've turned it on. You should be able to do it now.
Okay, I trust everyone can see the front page of my Prezi.
I can see it.
Great, great. So appreciate your time today. And today is really about a very focused issue. And as Mr. Chavez, as you've really already stated, this has quite a background. So we've already come quite a ways with testimony, with findings. Today, it's about a legal issue, which is frankly why I am now presenting as opposed to perhaps someone else. We have two variances, which you noted, have been consolidated, or excuse me, two applications for variances.
Well, they're not variances. The variances are very different from
I have it low.
what we have are conditional uses.
There we go. Okay, and I appreciate that distinction, sir. So what I want to do is just briefly, though, go through the history, and not all of it, because I actually looked at the interoffice memorandum sent by the city, and I thought it did a really nice job of summarizing what put us to the point of where we are today. And after the initial hearings, after the initial appeal, this matter did come before you, and you approved, if you will, the recommendation of the ZHE, and it went to the city council. And the city council then sent it back with essentially two questions. And I'm just looking at the memorandum. And basically it was to address and enter findings on the IDO requirements that the light vehicle fueling use would not increase non-residential activity, of course, within 300 feet.
Between the
that was
hours,
already addressed.
between the hours of 8 p.m. and 6 a.m.
Correct. And that was already addressed. That was already addressed January 19th before ZHE. Decision came out February 2nd. And I point that out because an appeal was not filed at that point on that particular decision. So I think that's already passed. What happened next, though, is the ZHE said, well, I want to hear about preemption. So preemption, again, was heard on February 16th. Decision came down, and that is, in fact, what brings us here today. Want to start with this. So you see the city brings it down, and the city specifically said when it remanded that they wanted to, the ZHE, to reevaluate the enforceability of the conditions of approval limiting liquor sales and to enter findings. So reevaluate the enforceability. So we did that. So this is now the ZHE's March 2nd findings. And I just want to highlight a few things. I'm going to go through this quickly because we've seen this. So first off, and most important, the finding was that if liquor is not sold between 8 p.m. and 6 a.m., both variances would be approved. And I note it's specifically paragraph 7, in which Mr. Lucero finds that with this restriction of hours, the variances would be approved. In other words, there would not be, or there would be sufficient finding that pedestrian traffic would not be increased. So we know that. I think what's also notable, though, is that there has been no findings in the record that the request for the light fuel variance would significantly increase foot traffic. All concerns, if you will, have been focused on the sale of liquor. And I think that's important, and I'll get to that in a few minutes.
So, Saito, let me interrupt you. You keep using the term variance. This is not a variance issue. This is a conditional use, and the conditional use criteria is highly distinguishable from the variance criteria. So I'm guessing it was just an oversight and you made a mistake. But if you could agree with me, let's stipulate for the record that in your presentation, where you call it a variance, you're actually calling it a conditional use. Is that okay with you?
I will refer to it as a conditional use. Yes.
Okay. Thank you.
So now we have the finding on preemption. And again, this is from the March 2nd, Mr. Lucero's decision. And what's notable here, though, of course, is that his finding is based on two pieces of, I'm going to use authority, and I'm going to use that rather loosely, but two pieces of authority. One is referred to as the Baker case or the miniatures case. The other is an attorney general opinion. And I think that's then takes us to the question, does the miniatures case or the attorney general opinion prohibit enforcement of the condition of approval regarding the hours of beer and wine sales? I mean, that's really it. Because what we already know is that as a conditional use is enforceable by the city. We already know that. So the question is, do these, again, broadly used authority take us out of that generally accepted practice of the city? So I think it's best to actually look at them. Look at these two pieces, and let's start with Baker versus City of Albuquerque. So what's notable about this case, first off, is this is a district court opinion from the Second Judicial District, 2008. Judge Rivera is a particular judge on this one. Mr. Chavez, you obviously understand then what a district court opinion means as opposed to an appellate decision.
I've read this opinion and I understand it. I understand every paragraph of that opinion, so you can brush over it for I mean, if you're trying to make a record, I'll allow you to do that, but I intimately understand the opinion.
Well, and I appreciate that. And perhaps a record is important because I think the challenge frankly, that will be coming is important. So I will go through it quickly, and I appreciate that. So let's just talk about the ordinance. The Baker ordinance, it had really three provisions. The first being new categories of prohibited products, miniatures, fortified wines, it was things like that. The second, the ordinance extended a 300-foot buffer to 500 feet. And I use the word buffer, it's in the opinion. Third, it added new locations. So what does that mean? Well, we're not just talking about churches and schools, we're talking about parks, we're talking about residential zones. And that I think is incredibly important. At that time, just as today, what existed in the Liquor Control Act is section 60, 6B10, which is this right here, which states that no license shall be issued. Just moving along, that is within 300 feet of any church or school. There's some other language in there as to how there can be a waiver and how there's an exception. But that's generally the language that we're talking about, and that's what they looked at. What the court did, however, is it then looked at what is precedent in the state of New Mexico. It looked at the manner in which the Liquor Control Act and preemption have been dealt with in prior cases. What is most notable is every authority that it relied upon dealt with an ordinance established by a governing body, whether it be a county or a city. Which again, going back to the Baker case, that's exactly what it dealt with. It dealt with an ordinance that established three additional criteria that are not found within the Liquor Control Act. So what did the court do with that? Well, it found and recognized legislative preemption in the field of the regulation of business. To be more specific, it basically said that it was a comprehensive scheme of regulation. It said the Liquor Control Act, in other words, covers the liquor industry. So home rule or non-home rule, it's a generally established practice, and it held that preemption, when an ordinance conflicts with the Control Act, Liquor Control Act, preemption applies. Well, that's pretty simple. But here's the issue. The issue comes down to then, if there is preemption here, I think this is where it would be, because we're talking about a city established ordinance. Or of course, it's just any local governing body, but we're talking about a city established ordinance. So what would be preempted? What would be preempted is this city ordinance right here. And I apologize again for the use of the terminology, but we're looking at 4-3D38C. This is under the liquor control, and it states that the conditional use approval pursuant to the section, when proposed within 500 feet of any residential area, basically you need then a variance. And I hope I used it appropriately that time. So the question, is that enforceable? Well, going back to the Baker case, that is remarkably similar to what we found here. 500 feet and additional areas outside of church and school. We have residential zone and parks. With our current ordinance, we have residential zones. So I think the question is really, is that particular ordinance preempted? Therefore, is it enforceable? Therefore, do we need basically a conditional use at all? And I think the answer is no, we don't. Relying on Judge Rivera's reasoning and the case law that she applied to this case. Perhaps a simpler way to look at it, though, is what Baker does not say. What Baker, frankly, does not address. And what Baker does not address is whether a conditional use is enforceable by the city or by the state or vice versa. It doesn't touch on it. Mr. Lucero pointed out in his findings, I'm going to, again, kind of broadly use the term concerned. His concern was on page 8. And I appreciate, Mr. Chavez, that you've read this. So I'm sure
Mr.
you
Salcedo,
have
let me
already.
Mr. Salcedo, let me interrupt you for a second. Let's go back to that IDO language for 43D38C. If you can bring
Yes.
that back up. Now, this is not in the 2018 IDO that is applicable to this application. Did you get this out of the newer version of the IDO?
This comes from, I have both versions here, and I appreciate you saying that, because I have to tell you, this is, my understanding, took effect in 2020.
No, well, again, we're looking at the 2018 version because anything before or after the application was submitted and deemed ready to hear by the ZHE under the IDO, then you are dealing with the IDO in effect at the time. And as I recall, we go way back to that date. And so the 2020 IDO is inapplicable to this application. Now, that language that you pulled out of 38C might still be in the 2018 IDO. I'd have to look, but it's not in 43D38C. So we need to deal with apples and apples before we go further. Do you know where this language would be if it is indeed in the 2018 version of the IDO, which is the one that is applicable to this application?
Yes, and I will represent that the language upon review at this exact moment is the same. There is no change, and it is found at 4-3D36C.
36.
And that is
good.
36C, and that is, according to the copy I have, revised and updated through May 2018. And again, just comparing the language right now, it's
no, I agree with you. I just
same.
wanted to make sure that we have the same citation. So we're dealing with 36C. And it looks like the language is either highly similar or the exact same language, but I don't know for sure. Well, there is additional language in the 2018 version, because the 2018 version after group home use includes the language of as measured from the nearest edge of the building containing the use. Okay, so that wouldn't be detrimental to your argument. I see where you're, okay. So the language is a little different, but it doesn't substantially change the argument that you are making.
Yes, correct. It does not. From the nearest edge. Yes, that language doesn't change a thing. It's still the 500-foot requirement, which again, going back to Baker, states is unenforceable. It is preempted by the Liquor Control Act. And again, Mr. Chavez, I know you've read this, so I don't want to, just
well, this is a new
go
argument.
over it ad nauseam.
You haven't made this argument before. I mean, you're challenging the IDO as it applies to liquor. You didn't do that in your submission, so you're making a new argument. So I mean, I'm giving you the flexibility you need to make that argument.
Well, I appreciate that, and what this, of course, means though is that, again, ordinance is not enforceable. So if the ordinance is not enforceable, that's a completely different regulatory scheme, if you will, that we're looking at. And again, would a conditional use even be necessary? Of course, it would not for at least one of the applications that's been submitted. So I want to go back though to what.
Let me ask you questions regarding this argument, and I apologize. It's just that you haven't made this argument in your documents that you submitted, in your argument, in your letter that you submitted to this appeal, and so we need to look at it closely. And I will have questions if we go off the record in an hour or so, and I don't have anything from you other than your presentation. So my question to you regarding this is that your position that any zoning ordinance that's generally applicable to location of a particular use that happens to sell liquor retail would be unenforceable under the Baker case or under anything else? Does my question make sense? So first, is it unenforceable under the Baker case? And second, if yes, is there anything else that would make it unenforceable in your estimation?
It's the reasoning of the Baker case, which I think is a little different than the Baker case. It's the reasoning of the Baker case that, again, establishes, because this is a comprehensive scheme of regulation, that any additional requirements, restrictions established by ordinance are preempted, are unenforceable.
But
that's our position.
But doesn't Judge Rivera in the Baker case specifically distinguish other ordinances? Because the ordinance in the Baker case regulated liquor. It didn't regulate zoning. It was in the zoning ordinance, but it regulated liquor entirely. And so it had retroactive effect, which essentially is, in my opinion, is worse than regulating liquor, because it shouldn't be retroactively effective, because it makes existing uses non-conforming uses, and it certainly impinges on the value of that use in the future. So in the Baker case, but Judge Rivera in the Baker case specifically recognized, and she acknowledged in the Liquor Control Act, section 60-6B F, I think, F2 or something like that, that allows for, that expressly allows for local governments to approve or disapprove liquor based on a zoning ordinance. It can't regulate with conditions the liquor use, but it can deny the application if it's of general applicability under 60-6B4 F. I think it's F. It might be E, but I believe it's F. So
it's
do you
F.
understand my question?
I do. And let me answer it though in two parts, because actually you started with a slightly different question. Judge Rivera certainly did recognize other laws that perhaps deal with local ordinances, and she makes a clear distinction there. And she talks about a few: fire occupancy, outdoor seating, things like that. She states specifically.
She expressly mentioned zoning.
Well, she says municipal zoning laws that regulate fire occupancy loads, outdoor seating, litter, or parking regulations. And this is on page 10. I'm looking at second to last paragraph. Okay. But then the statement is, these types of ordinances are not subject to the comprehensive and exhaustive laws the legislature directs to the issue of the sale of alcohol. So she distinguishes, the other state laws and how it relates to ordinances by, again, recognizing that the Liquor Control Act is meant to be comprehensive. She I think refers to it as a general law, which more goes to the home rule, non-home rule analysis, but she refers to it as a general law, applies across the state. However, going to now the second part of your question and your statement, what she talks about is she starts with 66B4F2. But I think it's more important to look at it as a whole. And actually, this was later, but let me get to it now. I'm going to bring up the language. I have it here somewhere. Here it is. Okay. So this is 60-6B-4F. Okay. And I believe this is the language you're talking about. It's certainly what Judge Rivera mentions. And it says the governing body may disapprove the issuance or apologize for the typo, the transfer of the license if. First, though, let me stop there, because what is this talking about? Well, this is talking about what the Liquor Control Board does. In other words, what the Liquor Control Act does with regard to the liquor license itself. So if you will, a separate process that would, my understanding is, follow this zoning process. It would then go to the transfer of the liquor license, and it would be a different proceeding. I believe, Mr. Chavez, you are much more familiar with that process than I am, but that's what this is talking about. But it starts with subpart 1, the proposed location, within an area of, is prohibited by laws of New Mexico. So local governing body can deny it if it's prohibited by the laws of New Mexico. Well, what does that mean? Well, we know that's 300 feet within a church or school, with exceptions in there. But that's what it's talking about. There's no other area mentioned within the Liquor Control Act. 2, the issuance or transfer will be in violation of zoning or other ordinance of the governing body. Well, obviously that means an enforceable ordinance. So I think what it's clearly saying is you cannot sell liquor out of your home. It still must be zoned for business or commercial use. This is the interesting one, I think. Number 3, the issuance or transfer would be detrimental to the public health, safety, or morals of the residents of the local option district. That's an interesting one.
Well, that's been addressed already, but that's already been addressed. There's clear case law on what that means. And that means
yes,
that goes to the ownership of the license, not it could go to the morals of the city of Albuquerque, but the proof for that is highly, in my opinion, it's almost clear and convincing evidence. So I don't think number 3 is relevant for this issue. But it's number 2 that is most relevant for this issue. I disagree with you that you're talking about merely an enforceable ordinance, because I don't know where you get that from, because there's no case law on that issue. Certainly, if you're arguing that a city cannot, through a zoning ordinance of general applicability, regulate uses, including liquor sale uses, through zoning, through reasonable zoning, I would say that there's no case law on that at this point in time. There's certainly case law on direct regulation, and there's case law on transferring and on ownership, but there isn't case law on that issue that you're arguing for. You're kind of brushing over it. But assuming you're correct, don't we have another issue to deal with? Because there's 2 uses that are being regulated through the conditional use process. So if you're arguing that the conditional use process that the city has under the IDO is inapplicable for liquor sales, we still have the retail gas station, the fueling, that is certainly doesn't fall under the Liquor Control Act. But I don't want to jump into that just yet. Certainly make your record regarding the Liquor Control Act.
Well, thank you, and I appreciate that. And to address your question about subsection 2, frankly, I think that is the Baker discussion. What is it talking about? Is it talking about any ordinance that a local governing body establishes? Well, of course not. The analysis in Baker says that cannot be it. You cannot have an ordinance that is in conflict with the Liquor Control Act. And the Liquor Control Act, again, is meant to be comprehensive because it basically provides a license. So a more restrictive ordinance is taking away what was given to the holder by the state. Essentially is what I understand the reasoning to be. If you, again, look at the case law, it talks about a county being prohibited from setting a set number of liquor license being operated in the state. Again, the reasoning is, well, wait a minute, the director, liquor control director already said you have a license. Now, as long as you comply with your general ordinances, you can operate. The local governing body cannot come in and say, well, wait a minute, now we're going to start restricting, because they're taking away something that the state gave. So again, in looking at this, I think it's saying what ordinance generally applies to business, not what applies to liquor. If it applies to liquor, it's preempted. So going now to, in fact, even the conditions that we have talked about, and let me pull that up here. I'm going to expand on that a little bit. If we're talking about, this is IDO 6-6A3E, and again, I apologize, I'm looking at the 2020 version, so let me get you the 2018. And it's 6-6A3, so it would be the same 3E.
The residential activity clause.
Yes.
Or
Yes.
regulation.
If that is interpreted or actually a practice and applied by the city to essentially focus on liquor, I think that's a problem as well. If it's applied, however, much more generally, in other words, does a convenience store in selling candy bars and, you know, chips, if that is seen to increase pedestrian traffic, well, that's one analysis. However, if it's viewed by the city as, well, liquor increases traffic, we're going to establish this to deal with that problem, I think that's preempted as well.
Let me ask you
because
this.
it focuses on liquor.
I get where you're going with this. Let me ask you this question. So is it your position that zones do not even apply to liquor uses? That is, that a liquor use does not need a particular zone, and that a liquor use can be set up in a residential zone. Is that your argument? Because it seems to be
No.
you're arguing that there's a broad preemption here. But maybe I'm misconstruing your argument, but it seems to me that you're arguing for an overly broad preemption that would preempt zoning entirely if it has any secondary impact on liquor through regulation.
And I can tell you, if you misunderstand or do not understand my argument,
No, I understand your argument.
That's my fault.
No,
well, it's not that broad.
Okay, so where are the
It's not that
limitations
broad.
then? Where are the limitations in your estimation?
Zoning specific to liquor.
Now you lost me.
Okay. Zoning specific to liquor is prohibited. So
No, I get
again,
that.
now,
Where are the limitations for the city? How far can the city go?
great question. And again, I clearly need to state it perhaps a different way. A liquor retailer must obviously comply with zoning regarding the sale of anything else. In other words, it cannot sell in a residentially zoned area. It needs to sell in an area in which any retailer can sell. That's not specific zoning requirement for liquor. That's a business zoning issue. That's a commercial zoning issue. If there is an ordinance that is specific to liquor, because the Liquor Control Act is comprehensive, it must fit within the framework. Now, what does that mean? Well, the Liquor Control Act already gives local governing bodies certain powers in certain areas to have discretion, if you will. One is found in 60-6B10. That's, again, the 300-foot church school. As you well know, there is some exceptions in there. One of them is that a local governing body can provide a waiver. And that's what the Attorney General opinion really talked about. It said, yes, but it's up or down. It's not you can approve a waiver and then add on stuff to it. You can't do that.
Agreed.
One of the other areas is what we just talked about, 60-6B4F in particular. And again, that's on the liquor side. That's a separate hearing. But our discussion earlier was that at least with subsection 3, there is some discretion. Now, Grant, I fully agree with you. It's one very high burden. And it's very difficult to establish, a safety issue. However, that is there. It is given by the Liquor Control Act to the local governing body. So with regard to liquor, unless the Liquor Control Act gives the local governing body the power to use its discretion, then the local governing body does not have it, does not have that discretion. It falls into, again, the general business purposes. my comment, and this is probably where I failed to properly communicate. When I was talking about, again, the the non-increase in non-residential activity, what I was saying there is the language seems to be general in nature. It seems to apply to all businesses, whether they sell, mostly Snickers or alcohol. It applies the same. And that, I would argue, is acceptable. Mr. Chavez, as you know, however, if in fact an ordinance in practice is different than perhaps the wording, and there would have to be a showing there. I think we may have a problem if it is restricted or if it is interpreted focusing on alcohol. I think that would be also preempted by the Liquor Control Act, because there's a focus on alcohol, perhaps already an assumption with regard to alcohol, a single product that's not specifically stated there.
So I have a few more questions. Is this a good time for me to ask my questions, or do you want to?
We are already all over the place, which I think is appropriate, because I want to make sure I'm answering your questions. My Prezi's just there. Right. I may have some information that might help us depending on your question.
Thank you so much. So I'm trying to narrow down the issue here. So I agree with you for purposes of argument that the conditions that the ZHE set that were remanded back to the ZHE to determine enforceability, I would agree with you that those conditions are unenforceable. And I should have caught that earlier. That's number one mistake I made. I can tell you I made two other mistakes in that process, but that's the first mistake I made. I should have caught it earlier, because I agree with you that not under the Attorney General advisory opinion, I don't think it violates the Attorney General opinion, because I think the Attorney General opinion is outdated under the Rivera opinion.
Yeah.
But I do agree with you for purposes of argument that the Rivera opinion would suggest that the enforceability of conditions that appear to regulate liquor sales is unenforceable. So that'll be part of my recommendation to the City Council, that the ZHE's conditions are unenforceable. He found that, by the way, as you know, and so that's true. I'm not so sure he hung his hat on that in denying the applications, but we'll get to that later. The next question I have, though, is let's assume for a moment that under your argument that there is a proposed application for just liquor retail, nothing else, no Snickers, nothing, just liquor sales within 300 feet of a residential zone under this conditional use regulatory process, under this condition that it cannot be you cannot increase residential activity between the hours of 8 p.m. and 6 a.m. Within 300 feet of a residential zone. So let's just assume for a moment that the application is just for liquor, nothing else, just liquor. So is it your argument that the application or that condition is unenforceable as to a application for a liquor retail sales, only liquor retail sales, because regardless of its being so close abutting a residential zone?
Yes, I think I understood your question, and the answer is yes. Of course, subject to 4F3, and I'm trying to shorten it there, 60-6B4F3, safety and health. Subject to that, yes, I think that is correct. As the sale of any other product. The sale of any other
liquor, though. My hypothetical was liquor only, because I'm trying to understand the limitations to your argument. Because I mean, and I understand you may want this to go to the courts to address this issue because it hasn't been addressed in the courts in New Mexico. in terms of a zoning ordinance of general applicability. So for purposes of my hypothetical, you would say yes for liquor. Now, what
Yes.
if the liquor license is part of a retail sale for other items? For example, the application that the ZHE considered was for liquor retail and the retail of Snicker bars and gasoline. So can the city, under your analysis, can the city regulate that use, even though it sells liquor incidentally with other retail items? Can it use that regulatory provision in the conditional use code, IDO, under E, the increasing residential activity between the hours of 8 p.m. and 6 a.m.? Can that be used to deny the application?
If it is because of the sale of liquor, no. Same answer.
Because there are other items that are being sold in that store. So
I guess I would say, but why is it being denied? Is it because of the sale of liquor, or is it because of the sale of all the other stuff?
Okay, now I'm understanding more your argument. Okay, so got it.
And this is, I believe, consistent with Judge Rivera's reasoning, again, on page 10, which is where she talks about that the other ordinances, as she refers to them, but let's just say the other products, so whether it's a fire occupancy code, parking regulations, or the sale of Snickers, that is not subject to a comprehensive and exhaustive set of laws by the state of New Mexico. So yeah, you actually can. The local governing body has more room to maneuver there. But when there's a comprehensive set of laws by the state,
understood,
that's where preemption comes in.
I mean, you're overgeneralizing, but yes, I agree. I mean, there are other issues that need to be analyzed. I think Rivera analyzed those issues in terms of preemption of liquor. But now my next question is, are you done with the preemption argument? Because that only gets us part to where we want to be. Did you want to move on to the other issues?
Well, I'll be honest with you. I think preemption is the issue today. And, again, I go to the findings of Mr. Lucero, which essentially is, again, the only thing we appealed, which is his paragraphs, basically 7, 8, 9, 10, in which he says it's preemption. Without preemption, let me get back to paragraph 7 here. Without preemption, we're there. And more specifically, without the Baker case and the Attorney General opinion, without relying on those two, broadly speaking, pieces of authority, the proper showing was already made. And we can move forward. The proper showing was made.
So it's your belief that the ZHE, I agree that the ZHE didn't include, well, he didn't analyze both questions that the city council remanded back to him, because there were two questions, and he based his denial of both applications on the one issue, which arguably is wrong. But it seems to me that he based the denial not on liquor, but on the fact that there is an increase in residential activity between the hours of 8 p.m. and 6 a.m. for liquor, but also for the gasoline sales. I mean, do you disagree with me in that? I mean, because I can remand it back to him to really analyze that, because he didn't analyze that. I have the authority, Mr. Saucedo, to analyze those issues for the city council. The city council has allowed me to do that. They've given me the discretion to reanalyze those issues if there is evidence, if there is sufficient evidence in the record. I think there is sufficient evidence in the entire record to analyze those issues. But I can remand it back again if you'd like. But there were two questions that the city council wanted to have reevaluated. And your appeal is on both of those questions. Your appeal isn't just on liquor. You may be recharacterizing your appeal today, but your appeal is very different than what you've characterized today. So I guess I'm kind of losing you a little bit. And the reason why I ask these questions is because it seems to me that there's evidence in the record regarding the subsection E in the conditional use criteria, the increasing residential activity, that it's presumptively an increase in residential activity between the hours of 8 p.m. and 6 a.m. when you have a 24-hour operation, right? Whether it's liquor, or even if we take liquor out of the equation, there seems to be evidence in the record that the hours of operation alone can be the basis for denial of the applications. Because again, whether it's liquor or any retail sales, it increases residential activity.
No, and I understand your point, and let me direct you to Exhibit C of
Exhibit
our
C in the record.
Yes, Exhibit C to our appeal. So to our written letter of March 15th, we attached Exhibit C. Frankly, it's already in the record, though. It is the notification of decision. January 21st was the hearing. This is, I believe, is what you're asking about, which is a light vehicle fueling station issue. It's conditional use to allow for a light vehicle fueling station as opposed to alcohol.
Yes.
With this, so preemption was touched on. More importantly, I would say enforcement was touched on. But what was clearly, I think, addressed, if we look at paragraph 9 and go down, in fact, to subparagraphs D and E. First, it's clarified that this is not 24 hours. It would be limited operation 5 a.m. to midnight. So there's that. Second, and again, this is as it states, a condition, if you will. Although alcohol sales may create a destination location, prohibiting sales between the hours of 8 p.m. and 6 a.m. would further ensure that there would be no significant increase in non-residential activities. Okay, great. But now let's look at 10, paragraph 10. On balance, applicant will have met its burden of providing evidence to satisfy the IDO section. Requires conditional use that we just talked about. Last part, if liquor retail use is restricted to prohibit liquor sales between the hours of 8 p.m. and 6 a.m. So I think Mr. Lucero did make a specific finding as required, as asked to by the city council.
I think he erred because, I mean, just with your stipulation, and I know it's in the record, just with your stipulation that the hours of the operation are between 5 a.m. and midnight, there is a presumption that has to be overcome, that it will increase non-residential activity between the hours of 8 p.m. and 6 a.m. And the reason why I say that is, and you know, in the record, I know there's a lot of analysis between destination location and passerby traffic. That's my second mistake in dealing with this appeal, these appeals earlier. I had lots of questions regarding destination location and passerby traffic. I don't know what that means. Those are not terms used in the IDO. And if those are traffic analysis terms, but I did not see a traffic analysis in the record. And I don't know if those terms have any impact on increasing non-residential activity, because the distinction between passerby traffic and destination location is irrelevant for determining whether there's going to be an increase in non-residential activity. If it's not irrelevant, I didn't see anything in the record that would make it relevant. That is, I don't know what those terms mean and how those terms would be applied to determine that there is not an increase in non-residential activity. And that, I should have looked at that closer before. And I do make mistakes. I've made a few, and that is the second mistake I made. The third mistake I made, and we can address that issue, but the third mistake I think I made in dealing with these appeals, they came in threes. So the third mistake I made is the ZHE's condition, the first condition where he requires that Murphy be the owner of the conditional use and that it not transfer to a new owner. That's unlawful. That's ultra vires. That's by definition unlawful under New Mexico law. You cannot do that in zoning. I should have seen that before. I can't believe I missed it. Let me tell you, I've actually lost sleep over it. It violates the case of, I think it's Meekum versus City of Santa Fe. Because in that case, the city of Santa Fe tried to do the exact same thing. And the Court of Appeals ruled, no, you can regulate uses, you can't regulate ownership. And so I think that's ultra vires as well. But back to my second issue regarding the destination, location, and passerby traffic. Can you define that for me? What do those terms mean? Or maybe Ms. Williamson can, if we can get her later on to explain those terms.
I'm hearing Officer Chavez. If you'll give me a few moments, I'll pull up the.
Let me swear you in, Ms. Williamson. Do you have your right hand raised?
I do.
Okay. Do you affirm to tell the truth, the whole truth, and only the truth?
Yes, I do.
Thank you.
Thank you. Just to clarify 2 points, if I may, in my submittal regarding the justification of that requirement, you're right in that it states that this request will not increase non-residential activity within 300 feet of a lot in any residentially zoned district between the hours of 8 p.m. and 6 a.m. Murphy is not a destination location, rather a consumers or passerby traffic. This will not increase the activity that is already active and present at this location, as the property to the north, the east, and the west are commercially zoned properties with commercial operations actively open. So you were correct in that what we call a destination and or passerby are traffic terminology. And if you can give me a few moments, I can give you some specific studies from Murphy, specific to Albuquerque, in which we show trip generation and how that's defined in terms of the different numbers for a destination rather than a passerby use.
Ms. Williamson, was that in the previous records? I don't recall seeing a traffic study.
Mr. Chavez, that was not part of we have not done a traffic study for this site, but we have done many traffic studies for our other sites in Albuquerque and New Mexico overall. And that's where that statement came from.
Got it. I understand. Okay. That was my concern. It's not in the record. And so, God, we've got many problems associated with these appeals. And I apologize to everybody for my mistakes. I don't know if we can clear the record with those. If you have that information now, Ms. Williamson, maybe you could try and clarify it. I guess that would be okay. I guess I have that discretion. I would like for it to be clarified and what those terms, why those terms are relevant for determining whether or not there is an increase in non-residential activity, not any time between the hours of 8 p.m. and 6 a.m. Are those other uses that you described to the north and did you say to the east? Are those other uses, are those open past the hours of 8 p.m.?
Hearing Officer Chavez, I know that the use to the southwest is open 24 hours. But if you can give me a moment, I'll pull up the actual, what we call the ITE, which is the traffic study terminology, which is how trip generation reports. And that's also what the city of Albuquerque and the Bernalillo County has required of this site specifically, and all the Murphy sites. And this is how we determine trip generation. So this is their language, not my language.
Right. And here's the issue here. I mean, this is arguably the first 24-hour use that I've seen that has come from this IDO. That is, I know in the previous zoning ordinance, the comprehensive zoning ordinance, this criteria, this regulatory criteria was not in the IDO. So there are clearly existing uses in the area that would essentially have met the previous ordinance, but don't meet the IDO. That's not an argument that can be made, but I'm trying to understand the difference, the distinction, and how that affects what non-residential activity is between the hours of 8 and 6 a.m. Because if we can't find anything in the record, I don't know if I can make that analysis.
Mr. Hearing Officer, so being not that we're lawyers, we're architects and planners, the fact that I stated that this is a destination, that this is not a destination and this is a passerby, we are experts in that field of delineation. And so if you will allow me, the ITE trip generation states that a destination is a traffic with the specific purpose of visiting the site being studied. And these are accepted by the city of Albuquerque, as opposed to passerby traffic, which is already on the way from an origin to a primary trip destination that will make an intermediate stop at a site being studied without a route diversion.
Right. Now that's generally in the previous record. I got that, but that doesn't answer the question on whether or not non-residential activity is increased between the hours of 8 p.m. and 6 a.m. because arguably non-residential activity can be included in destination activity or in passerby traffic activity, and vice versa. Residential activity can be included as well. I mean, so it doesn't help to do it. Doesn't help in the analysis of 6-6A3E, which is the residential activity analysis, unless you can shed some light on that issue, because it seems to me that, again, for the third time, it seems to me that there's a presumption that a 24-hour operation under the IDO now, under the now IDO, not what was previous, what is being looked at today under the IDO, that this 24-hour use, whether it's liquor or gas or selling Snickers bars, does increase non-residential activity between the hours of 8 p.m. and 6 a.m. Is there something that I'm missing in the record, Ms. Williamson or Mr. Saucedo? And I'm only asking these questions because there's not a strong record regarding these issues. And it seems to me that the applicants didn't address these issues. The ZHE didn't address these issues. Maybe the ZHE may have presumptively thought, like I'm thinking, that there is an increase because it's open 24 hours. And if that's the analysis that I need to do, I could do that, because unless somebody has rebut that presumption, it seems to me there's no other choice. That his denial is based on evidence that's in the record, or the lack of evidence in the record.
Mr. Hearing Officer and Mr. Saucedo, being that I'm not a lawyer.
Ms. Williamson, hold on a second. Ms. Becerra, can you mute your audio, please? Thank you. I'm sorry, Ms. Williamson.
Excuse me, being that I'm not a lawyer, if I may just address this in the guise of being the engineer and architect team, when the city of Albuquerque required a traffic study, and this is where this information comes from, they don't require a traffic study that looks at residential versus commercial traffic from the hours of 8 p.m. on. Their specific scope requirement that is mandated to us is to provide the trip generation from the hours of what they call the study time peak hours, which is 6 to 9 a.m. and then 3 to 6 p.m. That is the requirement from the city of Albuquerque and Bernalillo County. And so there is no mechanism that I'm aware of that specifically counts commercial versus residential traffic. And the city doesn't require that in what they directed to us to study for traffic. And so
I get that. I mean, I've been doing this a very long time, so I get that. But does that excuse the applicant from not submitting information for that criteria? Because that's the conditional use criteria that has to be analyzed here. I mean, that's the one that these two applications can be approved or denied on. And there's a presumption, in my opinion, in my humble opinion, that because it's open at these hours, that it does increase non-residential activity. I mean, geez, I don't even know what non-residential activity is, to be honest with you, but it seems to me that it's the applicant's burden to show what it is and what it is not, and whether or not there's an increase or whether there's not an increase. I mean, I hate to remand this back to the ZHE. I really do. I mean, I know the applicants have been dealing with this for over a year now. Mr. Saucedo, I didn't mean to stifle your presentation, but these are other issues that are just as important to me.
And again, thank you, Mr. Chavez, but do not worry about stifling my presentation. The truth is, I'm here to answer your questions. I'm here to provide you information. So whatever means is most productive, that's more than fine with me. I want to point out, essentially, I think everything Ms. Williamson just went through that she presented to the ZHE is reflected in his notification of decision, that in fact it was considered. And again, I am looking at the January, excuse me, not the January. Well, yes, I'm sorry. The document we just referred to for the conditional use following the January 19th hearing, paragraph 9, subsections A through E. This is what Ms. Williamson presented. This is the information that she provided with regard to the non-increase in non-residential activity. And it's listed there as she just described. So he certainly received it, considered it, and in doing so, then the way I read it, he then goes to paragraph 10, which says, I agree with all of this. Most importantly, though, subsection E, which is the 8 to 6 restriction, without that, I won't find it. You know, said another way, you could take out A or C, and he's implying that it would still fulfill at least his understanding, or we have persuaded him that there will not be an increase in pedestrian or non-residential activity. He's focused on E.
Right, and Mr. Saucedo, I mean, it's a great point, and I agree with you. And I didn't deal with it in the appeal by the neighborhood associations in AC 2010 and 2011 because it wasn't an issue that was brought up in the appeal. Yeah. But when it went to the city council, I believe, now I haven't read I honestly, so I'm at a disadvantage. I have not read the remand order regarding, is it AC 11? I read only one of the remand orders because that's the only one that's in the record. So I read the remand order regarding AC 20-11, I believe, or 10, which is the remand on the liquor analysis, whether or not the liquor is enforceable. But I didn't read the remand regarding the increase or non-increase of residential activity. I believe there was in the remand because the ZHE referenced it, but he didn't quote it. And so, do you have it in front of you, Mr. Saucedo?
I have it. Whether it's in front of me is a completely different issue.
Does anybody have that remand order that they could actually read to me right now?
Just a moment. Let's see.
I mean, I will include it in the record when I get it, but I'd like to hear what it actually says. Because I thought it was a remand to address that exact issue. And so if the city council remanded to address that issue, then the ZHE didn't address that issue.
Well, while I'm looking for this, just to clarify, what I have read to you from Mr. Lucero was following the remand.
Right, but he didn't. He
Okay.
didn't. I get that. I get that. And I read his decision several times for both issues. I didn't see an analysis for that issue at all, other than what's in the record, the previous record, regarding destination, location, and passerby traffic. But again, that doesn't address that issue. I mean, it may in a roundabout way, but I don't see the connections yet. I just don't see any evidence that connects those terms, those traffic analysis terms, with non-residential activity. And I understand Miss Williamson is telling me, and I agree with her, because I know that it's not required in a traffic analysis. So that raises a separate issue on how do you make that showing. But
Mr. Hearing Officer, oh, I'm sorry.
Yes, Ms. Williamson.
Did you still want me to read the remand? I have those here if you'd like me to read those.
Just the one dealing with the non-residential activity, which I thought was 11.
Well, I have just the, let me see.
I think it's Exhibit D in some of the documentation that Mr. Salcido represented.
I don't know. It's not. That's not the one.
Okay.
That's the one regarding.
Pardon me, Mr. Chavez.
Yes. Hello.
This is Lorena Patton. I have it pulled up here for AC 2011.
Ms. Patton, let me swear you in. Please
Yes,
raise
sir.
your right hand.
It's raised.
Okay. Do you affirm to tell the truth, the whole truth, and only the truth, ma'am?
I do.
Good morning.
Good morning. The decision on AC 2011 on December 7th, 2020, City Council voted to remand to reevaluate the enforceability of the conditions of approval limiting liquor sales and limiting the conditional use permit approval to a single operator. That's for 2011.
That's not the one I need. That's in the record, but there were two remands. There was one for each appeal, correct?
Yes,
Okay.
then I have the one for 2010.
That's the one that's not in the record. Please read that to me.
Yes, sir. Remand the matter to the zoning hearing examiner to address and enter findings on the IDO requirement that the light vehicle fueling use not increase non-residential activity within 300 feet of the adjacent residential zone districts between the hours of 8 p.m. and 6 a.m.
Thank you, Ms. Patton Quintana. Okay,
Yes,
so
sir.
that's what I thought it would say. They essentially looked at that subsection E, and so that's the issue that needs to be analyzed. And I don't think the CHE did that. And I get, Mr. Saucedo, that you're saying he did that, but he based it on liquor. Yeah, I get that. So
Yeah.
okay.
Mr. Chavez, when you get to a good point, can we take a break, please?
Sure. Let's take a 5-minute break right now, and let's all gather our notes, because I know we're making a very convoluted record, and my apologies. 5-minute break. We will come back at 10:17. Okay.
Very good.
Thank you.
Bye-bye.
Done speaking.
Bro, te dije que even if you have to stay.
Okay, is everybody here? Mr. Moya, are you here?
Yes, I'm here, Mr. Chavez.
Thank you so much. Mr. Saucedo, are you here? Looks like he is not. Hello, he is here. Okay, let's go back on the record. Mr. Garcia, are you ready to go back on the record? I mean, Mr. Sanchez, I'm sorry. Chris Sanchez? We have to wait for our court reporter. Mr. Sanchez, are you there?
I'm here. I'm ready to go.
Good, good. Okay, let's get started. Let's go back on the record after taking a brief break. So again, folks, you know, I do have the authority to modify the ZHE's decision so that it can conform to the IDO, essentially. But I'd like to pin down this issue of whether or not you can overcome that presumption that this operation does not or does increase residential activity between the hours of 8 p.m. and 6 a.m. Is there any evidence that demonstrates that it does not increase the non-residential activity? Mr. Saucedo?
Yes, and I appreciate that. And perhaps it is more just making a record now, but I think this is the way I see it. And I believe, again, it is the way Mr. Lucero viewed it. Looking at his decision again, the one we have been talking about following the hearing of January 19th.
I think he was wrong. I mean, I think he erred because he based it on liquor. I don't think that liquor sales, I mean, certainly retail sales in general will increase the non-residential activity. So he's wrong. I mean, anybody that goes into that store for gasoline or to buy a Snickers bar, whether they're destination traffic or whether they're passerby traffic, unless it can be shown that it does not increase non-residential traffic or non-residential activity, not traffic, activity, between the hours of 8 p.m. and 6 a.m., then the ZHE erred with that issue. That's my belief at this point.
And I appreciate that. I do. My understanding is, well, first of all, let me say, I understand there's a disagreement or you believe he is in error. I understand that. My understanding of his reasoning, again, is paragraph 9, subsections A through D. He's saying, my understanding of the reading is, if you just look at that in isolation, for the conditional use to allow for light vehicle fueling, for a light vehicle fueling station, that's enough. That was the showing that satisfied him taking alcohol out of the equation. A through D satisfied him. Now, again, it could have just been A or it could have just been D. I will admit he doesn't specifically state, or at least I haven't seen it, and frankly, I've been looking the last few minutes, that if you take out alcohol, or the sale of alcohol, the conditional use for the light vehicle fueling station is approved. In other words, it meets the conditions. I agree, he doesn't say that. But that's the way I read paragraphs 9 and 10 together. That is what he's saying.
Mr. Saucedo, in the record, can you tell me the page number of the record?
Yes, I'm looking at page 26, and this is of variance 144. So again, the light fueling station. And it's page 26. So it's exhibit C to our appeal.
And you're looking at his finding number 9.
Well, that's not his finding. He states that applicant stated that this is what we're doing. So I just say, pointing out a small difference there, but he's recognizing that it was the evidentiary showing. And again, this tracks A through D, what Ms. Williamson went through a few minutes ago, stating that she presented and put on the record. E, of course, is the 8 to 6 restriction. And then 10, he says you have to have the E. You have to have that one restriction. And again, I am reading into this, but I think it follows his reasoning. What he's saying is A through D would be fine, but when you throw in the sale of liquor, we need an additional requirement.
Right. I mean, that's the analysis that he used in the previous appeals under subsection D and C, the significant adverse impacts and the material adverse impacts on traffic. Those are the analysis for those two criteria.
Right.
And then he just kind of put them in for the analysis for the non-residential activity. Okay, I see where he's going with that.
Mr. Chavez, Mr. Hearing Officer, may I just clarify two things for the record? Because I think when we're talking about our justification, when me as the agent, the original agent as the architect, the planner, and my team of engineers, when we make a statement regarding the traffic, and I want to clarify these two things, this property is on the hard corner of Old Coors and Bridge. And so a traffic study or this question about residential versus commercial traffic, the ITE, which is the Bible for traffic engineering, assumes that the traffic is commercial because Old Coors, as identified by the MergeCog traffic data analysis map, is a minor arterial roadway, and Bridge is a principal arterial roadway. So any traffic engineer, if you went back and asked us to do this analysis, is going to do an analysis based on these two roadways, which are on the corner of this property, are carrying capacities for arterial roadways, which are not residential streets for residential activity. And so I just want to clarify that that's not a legal issue, but that is an engineering term, that these two properties are on arterial roadways and not on commercial roadways.
Right, but again, this isn't a traffic issue. per se. It's a non-residential activity issue. So traffic may be a part of that issue, but I think if the city council wanted it to be a traffic issue, they would have stated it as a traffic issue. But the traffic issue, for purposes of a traffic issue, that's in subsection D, right? Where it addresses material adverse impacts on traffic and pedestrian and the other issues there. I can't recall what they are, but we're talking about non-residential activity as a separate criteria. So I'm trying to pinpoint how non-residential activity is not increased with a business use, a commercial use, retail use that is open past the hour of 8 p.m. And so because that's the criteria, and this is an issue of first impression for the city council. For me, certainly under the IDO, as I said, the conditional use criteria in the comprehensive zoning ordinance that was superseded by the IDO did not include this criteria. So I'm trying to, number one, pinpoint what it is and how it applies and what the evidence is in the record. And I know you're trying to fit it into the cube, the pigeonhole. You're trying to pigeonhole it into a traffic impact analysis. Maybe that's all you can do. I don't know, but I don't think it's a traffic issue because that's covered under D and C. So does that make sense?
Mr. Hearing Officer, it does make sense. But in the terms of what we are required to do when we are trying to comply with City of Albuquerque zoning ordinances, IDO requirements, we as licensed architects and engineers are required to produce documentation that as a measurable information. We can't submit what our thoughts are or what our guess is. We are licensed to submit factual documentation that is based off, us stamping a drawing or a study. Could be a photometric study, it could be a traffic study. And so in terms of meeting this requirement for the City of Albuquerque, I don't believe that the City of Albuquerque even has a way to measure. There's no measurable way for a professional architect or engineer to provide this information. And again, this is not a legal argument. This is just more of my professional duty as their agent. There's no way to measure this question in a document that we would stamp and provide to the City of Albuquerque.
Sure, there is. There's one verifiable way, and that is to limit the hours. That is this conditional use criteria. If it's within 300 feet of a residential zone and uses, I think your use is within 40 feet of a residential zone, based on your site plan. And so that is the building is within 40 feet roughly of the residential zone to the south. So if the hours of operation are after 8 p.m. And before 6 a.m., then it presumptively is it increases non-residential activity. I mean, it could be as simple as that through this criteria, the city council has deemed that uses cannot carry 24-hour operations within 300 feet of a residential zone under the IDO.
Mr. Hearing Officer, having done a lot of these as the agent, it doesn't say that it doesn't create activity. It says that it doesn't increase activity. And so that, at least in our approvals that we've gotten in the previous in our previous submittals for varying different types of uses, the analysis that we're a destination, which is a definable term in the ITE versus a passerby, at least in previous cases, has been sufficient because it's a identifiable term that delineates the different types of traffic. And that was my argument, is that yes, we know there's traffic going to our store, but the IDO says, does it increase traffic? And because our use strictly depends on passerby traffic, our argument was that we're capturing traffic that's already there, that it's not additional traffic. So that was the reasoning for my wording in the original justification.
Sure, and I see that, I get that, but again, there needs to be a connection between the terms used and non-residential activity. And I understand that the ZHE normally doesn't take or review traffic impact studies in these conditional use applications, but this is the first one that I'm aware of that deals with a use that is open past the hours of 8 p.m. and before 6 a.m. next to a residential zone under this IDO. And so this is an issue of first impression. So it seems to me that that criteria has to be analyzed. And certainly if it needs to be analyzed in terms of traffic, then there needs to be evidence instead of just stating it. I mean, just stating a fact doesn't make it a fact. It needs to be proven by substantial evidence. And so perhaps a remand is absolutely necessary, which I despise remands because I usually deal with them again, right? I mean, there's usually an appeal, but I'm wondering if that's the appropriate course of action for this one issue, because the city council dealt with this issue and the city council wanted this issue addressed, specifically addressed. And I can't see that it's been specifically addressed by anybody. Salcedo is, I guess we're just kind of going back and forth. We should move on. Mr. Salcedo, is there more that you would like to add to the record?
Mr. Chavez, I understand your position, and I think I've addressed those as best I can. So I think I agree it's probably time to move on.
My apologies. I had to put me on mute because my phone was ringing and I don't know how to turn it off. So is there anybody that is here to testify regarding this appeal record in opposition? Mr. Benz.
Yes, I'm here.
Let me swear you in. And for the record, your name is Stephen Benz, P-H-E-N, correct?
That's correct.
Mr. Benz, do you affirm to tell the truth, the whole truth, and only the truth under penalty of perjury?
I do.
Thank you so much.
Thank you for giving me this opportunity to respond. Discussion has been a little bit all over the place. So I'll try to focus on what I, as a representative of the Los Altos neighborhood, and perhaps by proxy also the Alamosa neighborhood, we see as the basics here for this hearing today. Twofold, two issues that I think are basic. One is, of course, Mr. Lucero's decision on March 2nd and the appeal of that decision. And so my understanding is that the principal focus of this hearing was to determine or to make a case or comment on Mr. Lucero's decision. The applicants believe it was a wrong decision, so their objections were to be made in this in this hearing. The second thing is, as we've been talking about in the latter part, is the city council's concern for increased activity. So I would just say on those two issues, first of all, that I haven't heard anything here today that indicates that Mr. Lucero made a wrong decision on March 2nd, particularly pertaining to his observations on the so-called miniatures case and its applicability to this particular project. As we've mentioned, and I'll reiterate, in his decision, and I'll read from case 143 VA 2020-00143 and numbers 10 and 11. He's in reference to the miniatures case, he says that local government has the power to approve or disapprove the location of liquor licensed premises under state statute. The legislature has not given municipalities the power to impose limitations, restrictions, or conditions on a liquor license. And I haven't heard that really addressed here today, is that power of the state seems to me to supersede everything. That was what Mr. Lucero decided in saying that it would be outside the municipal authority to impose the restrictions that of what type of liquor could be sold and the hours in which they could be sold. And so Mr. Lucero, in his conclusion, said that that the proposed conditions of approval would be required to mitigate the negative impacts of the requested use, which is the increased activity. So there have to be those liquor restrictions in place to demonstrate that increased activity would be limited. Since those restrictions can't be applied, it seems to me that Mr. Lucero's decision is still the appropriate one until there's further, unless there's further evidence that the state does not have that overriding authority and that the municipality can impose those restrictions. In a general comment, I would say that all along the neighborhood associations have been pretty skeptical of the enforceability of the restrictions and contingencies that have been imposed on this particular project, particularly the liquor restrictions, but really all of them. And that the complexity of the discussion that we've had here today demonstrates that the enforceability is still very much in doubt, and the neighborhood continues to have concerns on that matter. Finally, I'll just say, in terms of the question that came up on increased activity and the nuanced discussions and definitions about destinations and passerby traffic and so on, and what that would signify. Yeah, I think that there has to be a distinction made between traffic and activity. We can say that the traffic won't increase because the same number of cars will go on Old Coors or on Bridge. But I agree with what I think Mr. Chavez is saying, and that is that by definition, as soon as that traffic stops at the site, activity is increased, particularly in the hours that the city council was concerned about. As soon as cars stop, there's necessarily an increase in noise. Of course, the lights are on all the time. There are voices, there are engines, there's potentially panhandler activity, fumes are ever present. And my point is that as soon as there's a stop, as soon as that people pull into the fueling station, activity is necessarily increased. And that's the key thing. The word that applies here, at least according to the city council's remand, is activity. Traffic may not increase. Traffic could go down, but activity could still increase because people are stopping, using the site, and they are well within the 300 feet distance from the residential areas. So that basically, for what we consider to be the basic issues under discussion here today, is what the neighborhood association wants to put forward. That Mr. Lucero's decision has not been successfully, a decision concerning the miniatures case and its applicability has not been sufficiently or successfully addressed, and that that subsequently everything that concerns increased traffic is still of concern and still needs to be resolved. So thank you for giving me that opportunity.
Thank you, Mr. Benz. Does anybody have any questions for Mr. Benz? Okay, and Mr. Benz, you have an opportunity to cross-examine Ms. Williamson regarding her testimony only, okay, not anything else. I'll allow you to ask her questions regarding that testimony, and I'll do that now.
No questions.
Okay, thank you. Ms. Becerra, I see that your hand is up. Would you like to proceed, Ms. Becerra? Ms. Becerra? Okay, Mr. Garcia, are you there? Ms. Becerra?
I'm here now.
Okay, hold on, Mr. Garcia. Ms. Becerra, for the record, your name is Diane Becerra. Please hold, raise your right hand and let me swear you in.
I've got my hand raised.
Do you affirm to tell the truth, the whole truth, and only the truth under penalty of perjury?
I do.
Thank you so much. Go ahead, ma'am.
Thank you very much for bringing all these points
to light, Mr. Chavez. I agree with a lot of your points. However, this activity or non-activity being increased is an issue that it's just very, very likely that there will be activity increased, whether it's traffic activity or not. And we have this huge project going on right as we speak here on this intersection of Old Coors and Bridge. I understand that there were some errors made, and it's now going to be another year before this actually finishes. They had to add another year to the construction because of some error. But anyway, bottom line is—
Are you talking about this application or a different application?
No, this application, but what I'm trying to get at is the activity and the traffic part of it, is that people are now going through our neighborhoods, okay? Because they don't want to wait for 10 or 15 cars through each light because of this whole project. So yes, this is a short-term issue probably, but it is very much an issue, and we're seeing the type of activity that's coming through, and they're going right through our neighborhoods. They're coming right to, at 40, 50 miles an hour. And none of that's going to really stop once all that's in place, when we have all these people coming through here. So the crime also is an issue that is very, very, very big with us here, because there have been murders, there have been accidents at that intersection. It's only going to be a higher speed because of the new Dolores Huerta highway that is proposed there, or it's already named that, but what I mean is when it's finally finished. But bottom line is, there is not, you all know what is happening with nationwide with our police situation. And so in order to try to diminish some of that, we do need to make some concessions here. They need to make some concessions here with regard to all that. Our neighborhood is way worse for what is going on right now, and having yet another establishment selling liquor, and who's going to really monitor that is another big question. My thought was that I would go in there on, at some point to try to buy alcohol and see if I was successful or not in buying it after.
Ms. Becerra, you're speaking a little too fast for me. But also, I would like you to limit your testimony to the issues of this appeal.
Okay, well,
hold on, ma'am. This isn't an opportunity for you to testify generally regarding your opposition, because it's a record review. So we need to narrow the scope of your testimony to what's in the record. Okay?
All I'll say, and I'll finish, all I'll say is that I requested from Crystal and Mandy when we were talking about being part of this meeting to make sure and include the whole entire record of our appeal and everything that has gone on in terms of hearings and decisions and all that, because they are identical, in nature, and they're the exact same thing. So I'm not sure whether that's been accomplished or not.
I did that already.
Okay, and I had said it in my email as well, but there's definitely a lot of issues with regard to the values of our homes being diminished by this issue here. The health reasons, you talked about that there's no evidence of any kind of health or safety issues. Yes, there is, big time. And so we're definitely, wanting those to be addressed, and also to make sure that, I don't know if you've read it or not, but there's a lot of issues there in what we appealed that have to do with our quality of life here, and with the crime, and with the congestion of traffic, and all that is in that appeal, all the way down to the fact that there was 2 realtors that submitted lots of data, lots of information with regard to what this is going to do to our property values, and also the fact that FHA will not even lend money to somebody who wants to buy a house.
Ms. Becerra, we've already addressed those issues, and again, the City Council has remanded the matter, but only on the 2 issues that are that were before the ZHE. So those other issues are not relevant for this hearing.
All I have to say, that's all I have to say. Thank you so much for your time.
Thank you, Ms. Becerra. Thank you so much. Mr. Garcia, would you like to testify, sir?
Yes, I would.
Let me swear you in. I see your right hand. Do you affirm to tell the truth, the whole truth, and only the truth under penalty of perjury, sir?
Yes, sir.
Thank you so much. Go ahead.
Yes, I want to thank all that spoke on behalf of Los Altos and Alamosa communities. And also, I have a question for Angela Williamson.
Okay. before you do that, why don't you get your testimony first and then you can ask the question.
Okay, I don't have any testimony relative to what's already been covered.
Okay, so you have a question for Ms. Williamson. Ms. Williamson, are you there?
Yes, I'm here.
Go ahead, Mr. Garcia.
Yes, my question to you, Angela, is you had mentioned there are 4 businesses around the intersection of Bridge and Old Coors.
Yes, sir.
Can you tell us which business resides southwest of the intersection?
Yes, just a moment. Let me pull up this was based off of Google Aerial. I do know that our analysis, when we looked at the increased traffic, primarily looked at the Circle K that is on the southeast corner, I believe, that is 24 hours a day operating. And I think there is a car dealership to the north, a mortuary to the east. Let me see here, just a moment. Let me look at my so there's a mortuary, a car dealership, and another convenience store that's located on the southeast corner. My apologies. That's open 24 hours a day. Those are the 3 businesses that I was referring to.
Okay, do they sell gasoline?
The Circle K does sell gasoline, yes.
Okay, so there is already a gas station in our neighborhood.
Correct.
Okay, thank you very much. That's all I had, really.
Thank you, Mr. Garcia. And Ms. Williamson, I have a question for you to follow up on Mr. Garcia's question. Out of those 3 businesses, were there any of those businesses, if you know or you can tell me you don't know, do you know if any of those 3 businesses were approved under the current IDO?
Mr. Hearing Officer, I don't know that. No, sir.
Okay. Thank you. Thank you. Okay, anybody else that would care to testify? Mr. Saucedo, do you have any questions for Mr. Benz, Mr. Garcia, or Ms. Becerra?
I do not, but I appreciate the opportunity.
Okay, thank you. Mr.
Chavez.
Saucedo, you do have time for a rebuttal if you would like.
Mr. Chavez, this is
Yes.
Linda Lopez.
Ms. Lopez, would you like to testify?
Yes, I would.
Okay, let me swear you in. I apologize. Please raise your right hand. Do you affirm to tell the truth, the whole truth, and only the truth?
Yes, I do.
Thank you so much. Go ahead.
Thank you very much, Mr. Chavez. And I appreciate the information, of course, that was presented this morning. Specifically, I wanted just to make some comments with regards to this application. Once again, we are here. And for the record, of course, too, is to say that there was a request to sell liquor at the southeast location that Ms. Williams did point out, which is a current gas station. There was also another request by Circle K on the southwest corner, which there is nothing at this point in time. The businesses that are to the north is to the north of the proposed site, there is a car dealership, but immediately adjacent to that is Bethel's Boots and Nelson's Meat Market. They have been landowners. The Nelsons have been around for many, many years. And we know what happens in our community. Those businesses do close at 6 p.m. So just wanted to make sure that was information. They're not open past 6 p.m. Due to the fact of, for the community and what we do, for the traffic patterns and such, I understand. But as Ms. Becerra did point out, is that even with the reconstruction that's happening at that intersection right now, there will be, I believe, also in supporting the neighborhoods, additional traffic and that will be happening and going through the neighborhoods that are immediately behind that wall on that particular corner that exists. So I just wanted to make sure of that. And again, I stand here in support of my neighborhood associations. Thank you, Mr. Chavez.
Thank you, Ms. Lopez. Mr. Saucedo, do you have any questions for Ms. Lopez?
I do not, but I certainly appreciate the senator participating today.
Thank you so much. So is there anybody else that would care to testify? I apologize that I overlooked Ms. Lopez's testimony. Anybody else here that would care to add to the record? Okay, Mr. Saucedo, go ahead. You have some rebuttal. Take your time, and I will not interrupt you this time, which is difficult for an attorney to do, as you know.
It is. And I, first of all, appreciate all the comments that I just heard. I really do. I think, Mr. Chavez, we have spoken now or talked extensively about the Baker case. So I don't think it would be helpful to go back and restate, I guess, our discussion. So I'll leave that alone. In fact, I just want to touch on one thing that has come up, and I think Ms. Williamson really addressed it, and that is the section we've been talking about and whether or not there is an increase in non-residential activity. And I appreciate Mr. Lucero's efforts in his decisions. I think, Mr. Chavez, your concern is that we're missing a few pieces there. We're missing kind of connecting the dots, if you will, connecting his reasoning. But in thinking about it and following, frankly, from what Ms. Williamson said, looking at possibly what could be an increase in non-residential activity and perhaps looking at the definition, I guess, of what that really is. Is it, in other words, traffic that is already on Old Coors and they're heading home, or they're heading to a friend's house? In other words, they were already there. They're already going to be traveling and they just stop. Is that what we're talking about? Or are we talking about them coming to this location from somewhere else and then intending to immediately leave? In other words, it's the destination. That's the way I understood those Ms. Williamson's comments. And I think it only makes sense that if we look at the ordinances and think about statutory construction, which of course includes a city ordinance, I think it has to be the passerby understanding the for non-residential use. And I say that because if it was anything else, if it's simply you have people entering this particular business, then it'd be much more efficient, frankly, much more understandable if the ordinance simply were to say the business must close at 8, because then nobody could show up and it's clear, it's understood. The business must close at 8. Nobody's going to be there. But that's not what it says.
I'm going to break my promise. So under your definition, which could be perfectly rational and reasonable of non-residential activity, you believe that the term residential activity means activity within the closest residential neighborhood only.
I think basically you're still talking about activity in the area, what's already there. As the term destination, again, as compared to a destination, in other words, where they're going for that purpose. And I believe any other reading would go against, well, frankly, against statutory construction, because it'd be much easier to simply say close down. If it means anybody going into the store, it would simply say you must close at 8. And it doesn't. So what it contemplates, the ordinance as written with 8 o'clock non-increase in non-residential activity, contemplates people going to the store, to the business at those hours. It contemplates that. It almost has to. So where are they coming from? And I think that's what was addressed. And I appreciate those comments because, again, I think it fits within your statutory construction principles and how that would work together and what was really intended, I guess, by the use of those words. So with that, again, I appreciate the comments today. I appreciate your time.
Thank you so much, folks. Okay, we will go off the record unless there's anything else. I will have a recommendation to the City Council within 15 days, I believe, and I shouldn't use up all of those 15 days. What I'd like for Ms. Patton Quintana to do is to circulate that remand order dealing with the non-residential activity. That's the one I want included in the record. The other one is already in the record dealing with liquor. So if you could include that, I requested it, but I was thinking maybe it couldn't be found. So Ms. Patton Quintana, could you send me a copy of that and send copies to Mr. Saucedo and anybody else who wants it in the record?
Yes, sir, I'll do that.
Okay, thank you so much. I appreciate it. Matter of fact, why don't we circulate it by using all the people that are on the Zoom call, the email with the Zoom call authority.
Yes, sir.
Everybody got it, okay?
I have that here, sure thing.
Thank you so much. Okay, thank you, folks. I enjoyed the discussion. Bye-bye.